everyone's day is going well. Mine is going great. Something about Mondays, I don't know, I love starting the week over again. It's like a clean slate, and I usually have the day off, well, except for my second job I work at, but that's okay. So anyway, I'm getting some recording done today, and it's been a couple of days since the recent filings for the 7M v. Katie Joy lawsuit have dropped, so I'm going to get to reading those today. Hopefully I can finish this in one take. If not, then it's going to be 2 parts. We'll see. So yeah, and I will be turning my camera off for this because I need my glasses on. Otherwise, it's just going to be too painful for you and for me. And I'm going to just put the filings up on the screen. So this way the entire screen goes to that, because that's really what deserves the attention here, not me. So let's get going. So for those of you who don't know, Katie Joy from Without a Crystal Ball has been in a lawsuit since 2022, I believe, with 7M, Robert Shinn. This was the story behind the was it Dancing for the Devil TikTok cult something. Anyway, the whole thing, in my opinion, non-legal opinion, non-professional opinion, well, maybe just professional, just human, is that Katie Joy orchestrated a lot of these claims against these people. Where we're at right now is they're still fighting over discovery, but discovery time has pretty much ran out. It's been going on for 3 years, pretty much. Let's get going, shall we? Okay, so I'm going to be reading the filings in the order in which they were filed, or at least the order in which they appear to be filed from the website. So this would be the first filing. This motion is the amended notice of motion and motion for discovery sanctions and reclassification of documents. This was filed by Katie Joy's side and against, 7M side. So this goes on to state, please take notice that on December 31st, or as soon thereafter as counsel may be heard before the judge, defendants, Paulson, Without a Crystal Ball, will move the court for the following relief. 1. Sanctions for spoliation of evidence, including corrected affidavits, targeted searches of social media archives, production of undisclosed accounts, adverse inference instructions, preclusion of damages, claims based on destroyed evidence, and attorney's fees. 2. Removal of improper confidentiality designations, including all, quote, attorney's eyes only designations and blanket deposition transcript designations. 3. Sanctions for failure to produce court-ordered financial discovery, including preclusion of damages claims based on lost social media income, or alternatively, reopening discovery for 60 days. 4. Reopening discovery for 60 days for depositions of Hannah Shinn, Shirley Kim, and Robert Shinn regarding newly discovered evidence, or alternatively, adverse inferences and preclusion of testimony. 5. Such other and further relief as the court deems just and proper. Next, we have the supplemental and reply memorandum of law supporting motion for discovery sanctions and reclassification of documents. So the way I read this is, the first filing that I just read is the notice of the motion and just outlining what the argument is going to entail. This is the argument itself, the actual motion explaining why it is they're asking for this. And then the following motion, the third one that I'm going to be addressing, is the one containing all the evidence supporting the argument in this filing. That's how I interpret it anyway. So here we have, now remember, this is from Katie Joy's side to 7M side. This memorandum addresses ongoing discovery disputes revealed through November and December 2025 correspondence and provides the court with a complete record for the December 31st hearing. Procedural posture. Defendants' motions addressing discovery sanctions were originally noticed for hearing on October 17th, before the non-dispositive motion deadline. That hearing was continued to December 31st. Following defendant's September 26 opposition memorandum, which raised discovery compliance issues, defendants attempted to resolve these disputes through meet and confer rather than requiring the court to rule on pending motions. On November 14th, defendants sent a detailed letter proposing reasonable resolutions to confidentiality disputes and spoliation concerns. And Exhibit A is proof of that. The letter requested a telephone conference to discuss these issues, offering to withdraw or hold pending motions in abeyance if the parties could reach agreement. Plaintiffs responded on November 21st, rejecting all proposed resolutions. More further proof. The parties then scheduled a meet and confer meeting for December 5th. Following that call, defendants sent a letter memorializing the discussion and areas of agreement. Plaintiffs responded by email the same day. The November-December correspondence revealed new issues and deepened existing disputes. Defendants now filed this amended motion on December 10th to provide the court with the complete record of these developments, including material contradictions between sworn affidavits stating accounts were, quote, deleted, and counsel's representations that they were deactivated. You're going to see moving forward that the whole problem behind this entire argument, which takes up a good chunk of these motions, comes down to the simple fact that Jennifer Moore just doesn't understand vocabulary well, in my opinion. Plaintiffs' refusal to search social media archives they claim to possess, plaintiffs' assertion of a procedural deadline for challenging confidentiality designations that doesn't exist in the protective order, plaintiffs' concession that, quote, social media monetization records are responsive immediately after claiming discovery requests were too vague to seek such records. Plaintiffs threatened contempt motions despite the non-dispositive motion deadline having passed. The non-dispositive motion deadline has now passed. Plaintiffs have threatened contempt motions in their November and December 2025 correspondence, but those threats are procedurally barred. Plaintiffs cannot seek affirmative relief after the deadline expired, particularly when they remain in far worse violation of the same court orders they invoke against defendants. Spoliation, the deleted/deactivated contradiction. The contradiction. Plaintiff's October 8th sworn affidavit state at paragraph 3, quote, now listen to this, pay attention. I deleted my social media presence as a result of the backlash from defendants' increased aggression this year. Okay? Both Miranda Derrick and James Derrick swore to this under penalty of perjury under Minnesota statute, yada yada. And in correspondence dated November 21st and December 5th, Ms. Stavig stated that her clients did not delete the social media accounts, but rather they deactivated the accounts and their archives are fully preserved. There are two problems with this assurance. First, Ms. Stavig's representations are not admissible evidence. No one gives a shit what the lawyer says. Come on now. Second, while the archives were preserved, they are not available to Ms. Paulson. And therein lies that problem, I think. I'm under the belief that either Jennifer Moore does not really understand basic vocabulary in, the language of English, or this was all done as some orchestrated attempt to obtain the entirety of the archives for these social media accounts, rather than just things that might pertain to just this lawsuit. Okay. And I want to point this out here real quick. I deleted my social media presence as a result of the backlash. Presence. That doesn't mean account. Account or profile is not presence. Having something made public for the public to view upon researching or just scrolling, that's having a presence on that platform. Removing that ability for the public to see it is removing the presence, yet it's not removing the profile or account necessarily, and chances are it's not. So the petitioners here in their sworn affidavits, they used the proper terminology for what they had done. It seems to be just Jennifer Moore that doesn't interpret words to mean what they are said to mean, in my opinion. Whatever. In an effort to resolve this issue, Ms. Paulson requested that the Derricks amend their affidavits and that their social media archives be made available to defendants. Whether or not they're available isn't dependent on whether or not they used terminology that the defendant can understand. As an alternative, defendants provided Ms. Stavig with a list of targeted search terms designed to ensure that all relevant information was preserved. Ms. Stavig again refused, making the somewhat outrageous claim that defendants are not entitled, on the record before the court, to obtain discovery regarding statements that plaintiffs had made about defendant or about the claims in this lawsuit. In fact, more than 3 years ago, defendants served discovery requests requiring plaintiffs to preserve and produce precisely this material. Despite this clear record, Attorney Stavig's December 5th email asserts that Exhibit A appears to be an attempt to request additional documents which were not asked for during discovery, and demands defendants provide the discovery request relevant to your request for these search terms. Yeah? Why is this so offensive? The requests are Interrogatory 11 and Requests 2, 5, and 19, served in August 2022 and court-ordered on January 2024. But even if they hadn't produced them at the time, plaintiffs' deletion or deactivation of their social media accounts mean that information that used to be arguably available to the public is no longer available. And therein lies the problem. It's not available to the public. It's still there, though. The undisclosed accounts. Oh, this argument is, wow. The contradiction about the main Instagram, TikTok accounts is not isolated. 2 other social media accounts were responsive to defendants' August 2022 discovery requests, but have never been disclosed, i.e., the Wilking Sisters 2 Instagram account containing videos of Miranda Derrick discussing this lawsuit, and the, quote, Without a Crystal Ball or Clue Instagram account maintained by Robert Shinn and or 7M Films, publishing statements about this lawsuit. Defendants first raised these accounts in July 2024 correspondence. Plaintiffs have never responded, not a confirmation or denial that the accounts exist, not an identification of ownership, not a statement about whether they were included in the August 15th deletion/deactivation, not even an objection. The court cannot evaluate spoliation without knowing what accounts existed and what happened to them. Plaintiffs' silence about these accounts while simultaneously claiming they deleted or deactivated their social media presence suggests they're hiding the full scope of their social media activity and demonstrates a pattern of bad faith concealment. Spoliation analysis. Under Miller v. Lankow, courts consider degree of fault, prejudice to opposing party, and whether lesser sanctions suffice. Fault. Plaintiffs eliminated their social media presence on August 15, 2025, years into litigation and after targeted discovery requests after court-ordered production. They concealed the existence of additional responsive accounts for over 3 years. They provided contradictory sworn testimony about deletion versus deactivation. The timing and contradictory explanations demonstrate bad faith. Right here, they provided contradictory sworn testimony. There's nothing contradictory about that. They said exactly what they did. And where's the contradiction? Amber explained it to you, and you think that now now there's a contradiction because you didn't understand the first time? Maybe the contradiction's in your head. I don't know. Allegedly. Prejudice. This is a defamation case about social media reporting. The social media content is the primary evidence of follower accounts, engagement rates, brand partnerships, monetization, and the accuracy of Paulson's reporting. Without complete disclosure of all accounts and their content, defendants cannot evaluate plaintiff's $4.7 million damages claim or defend against the defamation allegations. How can we show you that our reporting was accurate without first giving us the evidence to show you that our reporting was accurate? How about you make sure your reporting is accurate before you even know of the existence of any such evidence? Because that's what reporters do, or traditionally anyway. Lesser sanctions. Until plaintiffs clarify under oath whether accounts were deleted or deactivated, disclose all accounts that existed, and explain what happened to each account, the court cannot determine appropriate sanctions. D. Requested relief. Corrected affidavits within 7 days clarifying whether main Instagram, TikTok accounts were deleted or deactivated, what archives exist and in what format, whether archives can be searched, if original affidavits were wrong, why, whether Wilking Sisters 2 and Without a Crystal Ball or Clue accounts exist or existed, who owns, controls those accounts, whether those accounts were deleted on August 15th or at any other time, and what archives exist for those accounts. 2. Run targeted searches from defendant's December 5th, 2025 letter against all archives within 7 days or file sworn declaration explaining why they cannot. 3. Produce content from undisclosed accounts, including all posts, comments, metadata, and particularly content about this litigation, defendants, the Wilking family, or the federal investigation. 4. Adverse inference instruction that destroyed or concealed social media evidence would have been favorable to plaintiffs. 5. Preclusion of damages claims based on lost social media income when plaintiffs eliminated or concealed the evidence of that income. 6. Attorney's fees for the time spent addressing contradictory statements. In other words, it appears that Attorney Moore wants to be paid for her time having to learn what words mean. Seeking spoliation evidence and attempting to obtain disclosure of accounts plaintiffs should have disclosed in August 2022. Confidentiality designations. A. Blanket designations without justification. Plaintiffs designated entire deposition transcripts of Robert Shinn, Miranda Derrick, and James Derrick as confidential without line-by-line justification. What? You have to justify why a deposition is classified as something line by line? Like, that's got to take forever. No wonder why attorneys are so expensive. They have to do stupid work. Okay. Deposition testimony is presumptively public under Minnesota R Civil Rules of Procedure 2603, with the burden on the designating party to prove good cause for specific confidentiality restrictions. Plaintiffs designated the vast majority of financial documents as, quote, attorney's eyes only, which will be further adhered to as AEO, preventing Paulson from reviewing them. Under the protective order, AEO is limited to especially sensitive information, including, quote, private financial information, sensitive and private business information, medical records, and personal contact information. Under the designating part, or under is that paragraph 7? Is that how you say that? I think that stands for paragraph. I'm not sure, though. I'm going to say it anyway. Under paragraph 7, the designating party bears the burden of providing materials fall within the scope and that disclosure to the opposing party would cause, quote, significant harm. B, why Paulson needs access. Oh. Ready for a laugh, y'all? You ready for a laugh? Here we go. Paulson has specialized knowledge about social media monetization that her attorney does not possess. As a content creator, she understands platform payment structures, brand partnership economics, and financial relationships between creators and management companies. This expertise is essential to analyzing the September 2025 financial production and preparing her defense. I'm going to take a minute here and just break that down. Okay, what is this specialized knowledge? Okay. Specialized knowledge to me indicates someone who had a unique ability or opportunity to spend time studying and learning something that the majority of the population does not or would not have. That's specialized knowledge, in my opinion. She's a content creator. How many people are content creators that you know in real life, let alone online? Everyone. Okay, so I don't see how that's specialized knowledge, unless she went to school to learn like the SEO factors and shit like that, which we all know she didn't, unless she learned them in Spanish, you know? But platform payment structures, in other words, she has the specialized knowledge where she knows and understands exactly how these platform companies will pay you, what structure that is, what you get paid for. Okay? Isn't it basically just like the knowledge of anyone who has a job? Like, if you have a job, you know what day of the week you get paid. You know whether it's direct deposit or if it's in the form of check, and you know what exactly you're paid and what exactly you're paid for, right? That would be a business payment structure. You have specialized knowledge there. Brand partnership economics. So in other words, she has specialized knowledge in the economics of a company paying you for a specific job. Holy shit. If only everyone had that knowledge. It's like a quid pro quo almost. How does she understand this? And financial relationships between creators and management companies. Now that is interesting because I think that they're throwing that in there to reference or to represent 7M Management Company. But she never was a part of 7M, so it's not from 7M where she would understand this management company. So it would have to be she has other specialized knowledge in management companies, which means she herself has likely worked with a management company, or I'm going to go out on a limb here and say some sort of PR firm or something. Although I don't think that that's a very large limb. I think I could fall off the tree if I were to stand on that limb. But still, and by that I mean that it's most very assuredly almost the case, in my opinion. Management companies. I wonder who it is she has this experience with. That might send me down a rabbit hole at some point. And this expertise, her knowing these things, is essential to analyzing the finances that were produced. And this is information that her attorney could never possibly know or understand. Now, I'm sure that it's true that Katie Joy does have some further knowledge and experience in all of these things than her attorney. However, if I were her attorney, I wouldn't go around saying that like it's not a big deal. Because how long would it take her attorney to understand this? Not long at all, I'm thinking. In fact, she could probably even bill her client for the time spent learning these things. And since she is so far behind on things like, words, Katie might have one hell of a legal bill. The financial documents were produced 19 months late. Discovery had closed. Paulson needs access now to assist counsel in preparing defense strategy. See, counsel can't possibly come up with a strategy without the specialized expert knowledge of Katie Joy. Identifying relevant documents and understanding what the financial records reveal about the accuracy of her reporting. In other words, we need to find shit that supports her false reporting. And only Katie Joy can know what that might look like. Which that may actually be true because maybe Jennifer Moore's just not as twisted or whatever. In my opinion, okay, whatever. I'm getting petty. C. Plaintiffs' justification. Plaintiffs' November 21st letter asserts AEO designations are justified because Paulson has a, quote, demonstrated history of publicly disseminating plaintiffs' private information. The letter cites Paulson's July 25th Instagram post about a marriage certificate and her comments about the Derrick's demeanor during depositions. Paulson has posted public records obtained independently from government sources, including marriage certificates and addresses from public records databases. She has posted court documents from other litigation where she was not subject to confidentiality orders. She has commented on deposition demeanor based on her own observations. None of this involved breach of the protective order in this case, which only governs materials produced in this litigation. So, based on her own observations, but she's observing the documents and such that are not deemed as attorney's eyes only, that she would be observing them. So what's to stop her from sharing any information based on her own observations? I mean, she's talking about demeanor as though she's correct, but she would have no way of knowing that. I mean, I'm not sure that she broke any rules or anything there, but it's definitely questionable, and I think it's something that could definitely work against her and her efforts to try to get these things reclassified. It's not going to help her case, in other words. D. The protective order's two-tier system. The protective order provides two levels: confidential, accessible to parties but not for public disclosure, and attorney's eyes only, accessible only to counsel. Confidential designation already prevents Paulson from publicly disclosing financial documents, addressing any concerns about public dissemination. AEO is reserved for rare situations where disclosure to the opposing party, even under strict confidentiality obligations, would itself cause significant harm. What harm would result from Paulson seeing 7M's financial documents under confidentiality restrictions? See, this is how I interpret these things. If it were somebody other than Katie Joy, sure, maybe everything would have just from the get-go fallen, or most everything would have fallen under confidentiality. But because she has this history of revealing, and wrongly so oftentimes, a lot of private information for a lot of different people, it's more likely than not that she will end up doing that again here. So rather than offer up a situation where she can be held liable for it, they want to instead, first and foremost, prevent the harm being caused. The court sees reasons for this extra precaution, in my opinion. That's how I interpret this anyway. And I don't think they're wrong. Anyway. Plaintiffs offer only generic assertions about, quote, sensitive business information that would apply to any financial documents in any commercial litigation. They identify no competitive disadvantage, no specific harm, no reason why confidential designation is insufficient. E. Stavig's procedural argument. Stavig's December 5th email claims paragraph 7's 30-day deadline makes defendants' challenge untimely. I'm not going to read all the notes here, but I'm going to read this one. Plaintiff's pattern of non-communication has driven much of this case's procedural chaos. Despite defendants' June and July 2024 correspondence, including specific inquiries about discovery deficiencies, plaintiffs did not respond. Would that be during the time where she had surgery to remove the cancer from her body and then, was treated for cancer and was on the mend from that? Would that be the time in which they're referencing? Yeah. Defendants want to be compensated or otherwise made whole due to the chaos created from petitioner's attorney's cancer. That's so fucked up. Plaintiffs did not respond. Plaintiffs never advised defendants they intended to file for summary judgment. Then, after the court ruled on summary judgment and granted defendants leave to seek reconsideration, plaintiffs ambushed defendants with supplemental discovery and a second injunction motion based on social media content never previously identified to counsel. Plaintiffs may claim such communication would have been futile. The record proves otherwise. Defendants have repeatedly asked plaintiffs to identify objectionable content in writing. Plaintiffs have never complied. I'm pretty sure they did. That's my opinion, though. Whatever. Don't listen to me. I'm not an attorney, I should let you know. I have nothing in my background to offer up myself as any credible source regarding legal matters. So, FYI. Paragraph 7 states, the party seeking redesignation, quote, shall within 30 days of the requested change move the court for appropriate relief if the parties cannot agree. This is a deadline for seeking judicial relief, not a statute of limitations eliminating all rights to challenge designations. I'm not sure I think that might be incorrect. And I'm pretty sure coming up ahead, Stavig makes that clear. Defendant's timeline. September 26, 2025 memorandum challenged designations. October 17th, 2025 motions properly noticed. November 14th, meet and confer letter. November 21st, rejection by plaintiffs. December 10th, amended motion. Defendants have consistently sought judicial relief. Paragraph 7 also states, the party asserting that the material is confidential or highly confidential information shall have the burden of proving that the information in question is within the scope of protection. Stavig's claim that paragraph 7 does not require that I designate that the AEO documents fall within the scope of protection is backwards. The burden is on plaintiffs. F. Requested relief. 1. Remove all AEO designations. Documents may remain confidential, allowing Paulson access while preventing public disclosure. If plaintiffs believe specific documents warrant AEO, identify them by Bates number with sworn declarations proving A, why especially sensitive under paragraph 2, B, what significant harm would result from Paulson's access under confidentiality restrictions, and C, why confidential designation is insufficient. 2. De-designate deposition transcripts, except for genuinely private information like addresses, phone numbers, social security numbers, bank accounts. If specific testimony requires confidentiality, identify by page and line number with justification. 3. Court-ordered financial discovery, 22 months and counting. The January 29, 2024 order. The court ordered plaintiffs to produce tax returns and financial statements, documents showing compensation attributable to social media activity, compensation from booked performances, and compensation paid to 7M dancers with withholdings. The requests go to the heart of plaintiffs' $4.7 million damages claim, which is substantially based on lost social media income and brand partnerships. B. 19 months of silence, then partial production. Nothing happened for 19 months. No production, no supplementation, no requests for clarification. Finally, in September 2025, plaintiffs produced 7M Films tax returns and financial statements, some payout schedules, and brand partnership invoices. The timing was strategic, late enough to prevent follow-up depositions or expert analysis, but early enough to claim compliance before sanctions hearings. Well, if it was early enough to claim compliance or whatever, then it was within the time frame allotted, was it not? How is it her fault that you didn't properly prepare for the inevitable? C. The critical gap, platform monetization. Plaintiffs produced invoices showing what they billed brands for sponsored content. They produced nothing showing what social media platforms paid them directly. Social media creators earn income from two main sources: brand partnerships, documented in the invoices plaintiffs produced, and platform monetization, the payments Instagram, TikTok, Meta, Facebook, and YouTube make directly to creators based on content performance. These platform payments include creator funds, creator rewards, reels, play bonuses, stars, ad revenue, sharing. These platform payments include creator funds, creator rewards, reels, play bonuses, stars, ad revenue sharing, and similar programs. Platforms document these payouts in monthly earnings statements and annual tax forms. Without platform monetization records, defendants cannot verify how much income the Derricks actually earned from social media, whether that income declined due to Paulson's reporting or other factors like algorithm changes, or how money flows between the Derricks and 7M. The structure of those payments, whether platforms pay the Derricks directly or route payments through 7M, is direct evidence of the financial relationship Paulson reported on, which I find that statement very contradictory to the sentence before. The structure of those payments, regardless whether it's paid to the Derricks directly or through 7M, that it doesn't matter what route it takes. It's the structure of those payments. That's the direct evidence of the financial relationship Paulson reported. So why do you need to know the specific receiver of this route? Like, if it doesn't matter. Also missing, bank records showing receipt and distribution of income. Invoices show what was billed, not what was paid, where it went, or how it was split between 7M and the Derricks. What does that matter? D. Offered excuses. During the December 5th meet and confer, defendants raised the missing platform records. Attorney Stavig's email response began with, "You did not request social media monetization records in discovery. Your requests for production are vague and only state documents sufficient to show compensation. Your vague request does not equate to a request for social media monetization requests." Stavig's email continued, quote, "During our conversation, you also stated that during their depositions, my clients, James and Miranda, were not aware of these monetization reports. This statement is false. In fact, I stated that the Derricks were unable to testify with any specificity about these reports, but they did testify generally about these revenue streams." You see, she understands the difference between those interpretations, but she just doesn't understand presence and account. Ms. Derrick testified extensively about earning income from social media platforms. When asked, quote, "As a social media content creator, how do you make your money?" she answered, quote, "Through brand deals." When asked whether she made, quote, "any income from anything other than brand deals," she said, quote, "yes," and identified it as, quote, "from views on Instagram." She answered detailed questions about how 7M collected payments from brands and issued statements showing her earnings. Oh, so 7M collected the payments? So there's her answer. I mean, right there, right? James Derrick similarly testified about earning money through brand deals and answered questions about income from Instagram. Ms. Stavig was present for both depositions. Her clients understood exactly what monetization meant: platform payments from Instagram, TikTok, YouTube, and similar services based on content performance. They testified about it under oath. Even if Ms. Stavig was unaware how her clients earned their money, the Derricks knew. Stavig indicated that she would provide those documents, but has yet to comply. Why this matters? The 19th-month delay prevented follow-up depositions, expert analysis, and additional discovery before discovery closed. More fundamentally, plaintiffs claim Paulson's reporting about financial control was false and cost them millions. If true, financial records proving independent contractor relationships and transparent income flows would vindicate them. Instead, plaintiffs withheld financial records for 22 months, produced partial records only under pressure, designated everything so Paulson can't see it, and still have not produced the platform payment records showing how income actually flows. F. Requested relief. Preclusion. Preclude damages claims based on lost social media income unless plaintiffs produce within 14 days. 1. Complete platform monetization records from all platforms showing monthly payments from January 2020 through present. 2. Bank records showing receipt and distribution of all social media income. 3. Any agreements between the Derricks and 7M regarding income sharing or management fees. 4. Documentation of withholdings and splits. If plaintiffs cannot or will not produce these records 22 months after the court ordered them, they cannot prove their damages. Reopen discovery. If the court declines to preclude damages claims, reopen discovery for 60 days to permit follow-up depositions about the September 2025 financial production and any belatedly produced platform records, expert analysis, and subpoenas to platforms if necessary. Additionally, adverse inference instruction that platform records would show income less than claimed or structures inconsistent with plaintiff's narrative. Order compelling production within 14 days with progressively stronger sanctions for continued non-compliance, and attorney's fees for 22 months of attempting to obtain court-ordered discovery. 4. Reopening discovery. New evidence demands new depositions. Discovery closed months ago, but the evidence didn't stop coming. On July 25th, federal agents raided Robert Shinn's properties in California. According to a public forfeiture notice issued by the U.S. Postal Inspection Service on September 9, 2025, federal agents seized $105,222 in cash from Shinn that day. Money they claimed was connected to, quote, violation of federal law. Then, on October 8th, plaintiff's own California attorney filed a sworn declaration in their related litigation acknowledging he'd received the forfeiture notice and referencing, quote, a pending criminal action affecting his clients. Meanwhile, back in Minnesota, plaintiffs swear under oath that no criminal charges have been made, a carefully worded statement that conspicuously avoids addressing whether investigations exist. Wow, you mean to tell me that people went into a deposition and they carefully chose their words? Holy shit. Imagine if everyone did that, right? What the fuck? How dare they not get it confused and tell me what I want to hear? They chose their words carefully so they were accurate. Fuck them. Like this, that's how that reads. That's crazy. They built their entire injunction motion around the premise that Paulson's reporting about federal investigations is false and defamatory. Both stories cannot be true. The documentary evidence, public records filed in court issued by federal law enforcement, proves the investigation exists. Defendants need depositions to explore what these records mean. Oh, I agree. I think both sides should get more records about what these, what this means, because the investigation, it seems, did not exist before Katie Joy's reporting and encouragement of viewers to report Shinn and to report Shinn to the county sheriffs, to sign a petition demanding his arrest, and to report him to the FBI and various other agencies. So I'm willing to bet that there's a reasonable chance, very, very reasonable chance, that any investigation that now currently exists could very well be due to, in large part, Paulson's reporting and insistence that her viewers assist her in getting this investigation started. A, the missing witnesses. Although I can't help but to wonder if this lawsuit is the exact reason why Katie Joy did that. because then it's almost like, oh, look, see, it turns out I was right after all. Not quite, I don't think, in my opinion, whatever. The missing witnesses. September 2025 financial production revealed that Hannah Shinn appears as a shareholder in 7M Films and throughout the financial records in contexts suggesting significant corporate authority, and that Shirley Kim is closely tied to 7M's business operations. The production also disclosed that Hannah Shinn sent Kylie Douglas's termination text. In their February 14, 2023 Rule 2601 disclosures, plaintiffs identified both Hannah Shinn and Shirley Kim as individuals with discoverable information, quote, regarding the facts alleged in plaintiff's complaint and defendant's answer, listed as, quote, available through counsel. Despite this early identification nearly 3 years ago, plaintiffs never made either witness available for deposition during discovery. If this is true, then why didn't Moore quote Amber Stavig as saying that these two were individuals with discoverable information? Like, why didn't she quote that? Because it seems like that's just an assumption, possibly an assertion made by Moore, and then the following is actually what Amber Stavig said, because it gives you the impression that Amber Stavig actually stated all this stuff, but why not quote it if that's the case? Never made either witness available for deposition during discovery. If plaintiffs had complied with the court's January 29, 2024 order and produced financial records timely, defendants would have seen the extent of their involvement and noticed depositions during regular discovery. Instead, the 19-month delay concealed their roles until discovery had closed. Wait a minute, so Moore is arguing that way back in 2023, Stavig allegedly, according to this statement, had said that these two were individuals with discoverable information and that Stavig would produce the information upon request or whatever. So the defendant's attorney was made aware of these two since February 2023. But now they're complaining that they didn't have enough time to depose them or subpoena them. Well, who said that you had to wait for Stavig to do that? Why didn't you just go ahead and do that? I mean, I can't help but to wonder that. Then you wouldn't be in this situation, right? I mean, am I wrong? That reads as like, yeah, sure, she told me that they existed and that they might have discoverable information, but she didn't tell me that I would have to be the one to subpoena them. Like, what? That's how that reads. That's oh my God, that's ridiculous. B, the incomplete deposition. Robert Shinn was deposed during discovery. I keep wanting to say disposed. I don't know why. Robert Shinn was deposed during discovery, but that was before the September 2025 financial production, the July 25th federal raid, the September 9th forfeiture notice showing $105,000, $222,000 seized from him, and the October 8th, 2025 declaration from his own California attorney acknowledging the criminal investigation. Shinn needs to be redeposed about these developments. Yes, he may invoke the Fifth Amendment, but, that's his right. But defendants are entitled to ask the questions and establish a record of what he will and won't answer. C, requested relief. Reopen discovery for 60 days, limited to depositions of Hannah Shinn, Shirley Kim, and Robert Shinn. Scope, roles at 7M, corporate structure, financial relationships, the September 2025 production, the July 2025 raid, the forfeiture, and non-privileged aspects of the federal investigation. No other discovery reopen. In other words, open it just for us to ask these specifically targeted questions, but the other side can't do any follow-up or ask their own shit as a result of the new evidence that's come about. Only our side. What? Alternatively, if reopening is denied, defendants request adverse inferences that testimony from these witnesses would have been unfavorable to plaintiffs, preclusion of their testimony at trial, and admission of the forfeiture notice and Gutenplan declaration as substantive evidence under Minnesota rules evidence. Conclusion. Plaintiffs have systematically violated court orders, destroyed evidence, concealed responsive accounts, and obstructed discovery for years while simultaneously seeking to silence defendants' constitutionally protected journalism. The contradictions between their sworn statements in Minnesota and California, the spoliation of social media evidence central to this defamation case, and the 22-month failure to produce court-ordered financial records warrant the sanctions requested. Defendants respectfully request that the court grant the relief set forth above. And that's the end of that one. Okay, the next filing is the Declaration of Jennifer Moore, which I said before, this is where she provides the evidence that was referenced in the last filing we just read. So here it starts off with, I declare penalty of perjury in my name. I'm a licensed attorney. I submit this declaration. And here's Exhibit A and what Exhibit A depicts, and B, and etc., going all down the list. And then here comes the evidence. Exhibit A. This is from Jennifer Moore, Katie Joy's attorney, to Amber Stavig, 7M's attorney. And it goes on to state, Dear Ms. Stavig, thank you for agreeing to meet and confer regarding the outstanding discovery disputes in this matter rather than requiring the court to rule on the pending motions concerning confidentiality designations and spoliation. I believe we can reach a reasonable resolution that serves both parties' legitimate interests while avoiding unnecessary motion practice. This letter confirms the issues for our meet and confer discussion and proposes a framework for resolution. 1. Confidentiality designations. A. Deposition transcripts. Your clients have designated the entire deposition transcripts of Robert Shinn, Miranda, Derrick, and James Derrick as, quote, confidential. These blanket designations are inconsistent with the protective order and Minnesota Rule of Civil Procedure 2603, which require good cause for confidentiality restrictions. Deposition testimony in civil litigation is presumptively public, and wholesale designation of entire transcripts is improper. The protective order places the burden on the designating party to prove information falls within the scope of protection. Proposed resolution. I propose that the deposition transcripts be de-designated in their entirety, except for narrowly tailored redactions limited to like home address, personal telephone numbers, social security number, yada yada. This approach protects truly sensitive personal data while allowing my client access to the substantive testimony necessary for her defense in this defamation case. That's funny. If that's your reasoning for wanting this, well, your client already has access. This is only confidential. Your client just can't distribute it out to the public under this confidentiality classification. So this approach protects the truly sensitive data while allowing my client access to the substantive testimony. Well, you already have that. Your client has the access, and it protects the truly sensitive data. You're saying that this is what this will give us when you already have that. B. Attorney's eyes only designations. Your clients have applied highly confidential attorney's eyes only designations to the vast majority of documents produced, including tax returns, financial statements, and business documents. Under the protective order, the highest level of protection is reserved for, quote, especially sensitive information where disclosure to the opposing party would cause, quote, significant harm. The current designations prevent my client, Catherine Paulson, from reviewing the very documents central to this defamation litigation. This is particularly problematic because the case revolves around statements Ms. Paulson made based on her research and reporting. Okay, she needs access to this material to prepare her defense and to meaningfully participate in case strategy. This is particularly problematic because the case revolves around statements Ms. Paulson made based on her research and reporting. Well, then if she is so she's defending her statements on her research and reporting, what does she need more research for to defend her statements? Like, if she had reasons through research and reporting to make these statements, then what the fuck does she need proof of these statements for if she already obtained enough for her to make the statements? This is so backwards how this is done. Like, it's like almost like anyone can go out there say whatever the fuck they want. Even if it's, logically plausible, they can go out there and state it as fact, and then upon being sued, demand to be shown proof of their statement, even though they had no knowledge, no assurance of this proof having existed before the statements were made, or before the court came involved. That just, how is that fair, really? Like, seriously. Like, is that normal? Is this like normally how defamation lawsuits go about things? Or is this just like a nuanced thing? I don't, anyway. Proposed resolution. I request that all attorney's eyes only designations be removed. Documents such as tax returns and financial statements may remain designated as confidential, accessible to Ms. Paulson, but subject to protective orders, prohibitions on further disclosure. Oh, so you do know what that means, because up above I was under the impression that there was another word that Moore didn't know. But they should not be restricted from my client's review. If you believe specific documents warrant attorney's eyes only treatment, I ask that you identify those documents with particularity and provide a factual basis demonstrating the, quote, especially sensitive nature and potential for, quote, significant harm as required by the protection order. Go away. Okay. Sorry, I was getting a phone call. 2. Social media archives and spoliation concerns. A. Deleted/deactivated accounts. In my July 26, 2024 correspondence and September 26, 2025 declaration, I identified serious discovery deficiencies related to social media accounts, specifically Miranda, Derrick's Instagram and TikTok archives. Your clients admitted in sworn affidavits that they deleted their entire social media presence on or around August 15, 2025, years into this litigation, and after receiving targeted discovery requests specifically seeking this material. This wholesale destruction eliminated the primary evidentiary source underlying this defamation case. 2. Wilking Sisters 2 Instagram account. Videos of Miranda Derrick appear on this account, including videos where Ms. Derrick allegedly discussed this lawsuit. This account was never disclosed in discovery responses, despite specific interrogatories and document requests. What are the chances that Katie Joy herself was behind the creation of those accounts, only to then delete it and then start a rumor that it was actually ran by the opposing side? There would be like a sense of controlled opposition, would it not? I really hope that's not the case, because then really we end up at a point where just nothing can be trusted. We may be there already. I don't know. 3. Without a crystal ball or clue Instagram account. I have been advised that Robert Shinn and or 7M Films maintains this account, which has published statements purporting to be comments directly from 7M and or Mr. Shinn about this lawsuit. This account was also never disclosed. I want to throw this out there right now. If by some chance the emails associated with these 2 Instagram accounts come back as like a Proton email or, I don't know, a deleted Gmail account, that might be, I don't know, it's not going to look good. It's not going to look good. B. Archived content from deleted accounts. Your clients deleted their TikTok and Instagram accounts entirely on August 15, 2025. You state that as though it's fact. While they claim in their response brief that they, quote, have retained copies of all relevant social media content, no such archives have been produced. Minnesota law and common practice recognize that social media platforms will allow users to download complete archives of their accounts in searchable format, though these archives would include all post stories, videos, and images, comments and interactions, direct messages to the extent responsive to discovery, metadata, including dates, times, and engagement metrics, content that may have been deleted from public view but remains in the archive. Proposed resolution. 1. Complete Instagram and TikTok archives. Please produce the complete Instagram and TikTok archives for Miranda Derrick and James Derrick in native searchable format. The archives should include all content from the inception of the accounts through the deletion date of August 15th, 2025. Now, it does not state there that she just wants the information that results from these specific targeted search queries. She says there, give it all to me, all of it, from the beginning to the end. I want everything. 2. Wilking Sisters 2 account. Please confirm whether your clients own, control, or have access to this account. If so, please produce all content from this account, including any videos featuring or referencing Miranda, Derrick, and any content discussing this litigation. 3. Without a Crystal Ball or Clue account. Please confirm whether Robert Shinn, 7M Films, or anyone acting on their behalf owns, controls, or has access to this account. If so, please produce all content from this account, particularly any posts about this lawsuit or about Ms. Paulson. I mean, the name of the account doesn't even give any inclination or suggestion to be about 7M. It's all about Katie Joy, and now she wants everything from that account. 4. Format and timeline. I request that these materials be produced in native format with metadata intact within 14 days of our meet and confer discussion. 3. Meet and confer discussion. I propose we schedule a telephone conference within the next 7 to 10 days to discuss these issues. My goal is to reach a reasonable accommodation that protects your client's genuinely private personal information, provides my client with access to the evidence she needs to defend this case, obtains the complete social media records that should have been preserved and produced in discovery, avoids the need for motion practice and judicial intervention. If we can reach agreement on these issues, I am prepared to withdraw or hold in abeyance the pending motions addressing confidentiality designations and spoliation. However, if we cannot reach resolution, I will need to proceed with those motions and may need to supplement them based on your response to this letter. Please let me know your available dates and times for a call, yada yada. Okay, so there's Exhibit A, I guess. Exhibit B. This is Amber Stavig's response to the letter we just read. Ms. Moore, we have reviewed the issues outlined in your November 14, 2025 letter and are prepared to discuss them in detail during our scheduled meeting. 1. Confidentiality designations. A. Deposition transcripts. Plaintiffs reject your demand to de-designate the deposition transcripts of Robert Shinn, Miranda Derrick, and James Derrick in their entirety. You have provided no basis for removing their use as confidential, nor have you given a reason as to why these remain confidential. As you have provided no legal basis for redesignation of the transcripts, we will not agree to redesignation. B. Attorney's eyes only designations, AEO. The AEO designations were made in good faith, consistent with the protective order, and are reserved for documents containing highly sensitive business, financial, and proprietary information, the disclosure of which could cause significant competitive, commercial, or reputational harm. Plaintiffs therefore categorically reject the assertion that our, quote, highly confidential attorney's eyes only designations are improper. The documents you reference, including tax returns, internal financials, and non-public business records, fall squarely within the type of especially sensitive material warranting AEO protection. Disclosure of this information to Ms. Paulson personally presents a genuine risk of harm, particularly in light of her demonstrated history of publicly disseminating public's private information and plaintiff's current motion for a temporary injunction, which is under review by the court. Your request to remove all AEO designations is unsupported by law and inconsistent with both the protective order and the highly sensitive nature of these materials. In other words, we made these AEO for the reason in which is stated you make something AEO. But when in terms of your client, there is an even greater risk of exposure because that's what she does. And we're trying to get the court to stop her from doing that. In my opinion, allegedly, whatever. We will not agree to blanket reclassification, but if you believe specific documents were misdesignated, please identify them by Bates number and we will review them individually. Plaintiffs remain willing to meet and confer regarding particular documents, but the record provides no basis for dismantling AEO protections across the board where you have not identified why they were misdesignated. 2. Social media accounts. Plaintiffs categorically reject your accusations regarding supposed spoliation and non-disclosure of social media accounts. The voluntary deactivation of personal social media accounts on August 2025 was not undertaken to destroy evidence. It was a response to ongoing harassment, threats, and misuse of plaintiffs' online presence. These accounts were deactivated, not deleted. Plaintiffs have full access to their deactivated content. Plaintiffs have already confirmed that relevant content was preserved prior to deactivation, and your effort to reframe this as, quote, wholesale destruction is both inaccurate and unsupported. Any suggestion that plaintiffs intentionally destroyed evidence is baseless. Plaintiffs continue to meet their discovery obligations and will review your requests in the ordinary course. We will not, however, accept unfounded allegations of misconduct as a basis for demanding expansive production of social media archives that extend far beyond the scope of relevance or proportionality. If you can identify specific content that you believe exists and is relevant and responsive, we are willing to evaluate those requests. However, there is no law which states that plaintiff in a lawsuit must maintain a public social media presence. Meet and confer. We remain committed to protecting plaintiffs' private information while ensuring that discovery proceeds in a manner that is proportional and consistent with the governing rules. Plaintiffs are willing to confer in good faith, but we will not be pressured into concessions based on unfounded allegations or the threat of unnecessary motion practice. If you believe specific materials remain outstanding, please identify them with particularity, and we will evaluate those requests in the normal course. Plaintiffs will participate in a conference with the aim of narrowing any legitimate disputes, but your decisions regarding motion practice are solely your own and cannot be used as leverage to compel inappropriate or overbroad discovery demands. We are available to meet as followed, yada yada. Okay, next we have another letter from Amber to Jennifer Moore. Dear Ms. Moore, pursuant to court's prior order on discovery and in accordance with the Minnesota Rules of Civil Procedure, we hereby formally demand the immediate production of all discovery materials that your client, Katie Joy, has represented to be in her possession, custody, or control. We are particularly concerned by your client's ongoing public representation suggesting the evidence of relevant undisclosed materials. On June 24th, 2025, Katie Joy posted a video on YouTube stating that she has, quote, dozens of clips of plaintiffs, which she described as evidence that she will be able to use if we go to trial. To date, no such materials have been produced or identified in her discovery responses, nor have they been disclosed in any private log. If such materials exist, they are plainly responsive and must be produced without further delay. It has also come to our attention that Katie Joy has appeared on NewsNation and made public statements concerning plaintiffs. We hereby demand the immediate production of all correspondence, communications, and documents involving third parties, including but not limited to NewsNation, other media outlets, platforms, or journalists that relate in any way to plaintiffs. This demand encompasses all emails, direct messages, text messages, interview requests or arrangements, draft statements, and any other communications referencing plaintiffs or this litigation. Additionally, please provide the following outstanding discovery required by the court's January 29, 2024 order, Interrogatory 12. Interrogatory 12. State the name, address, and contact number, yada yada, of every person who gave information to Katie Joy or without a crystal ball, shared information regarding the defendants or the petitioners, and under all of these different platforms, basically is what this says. Request number 17, produce any and all tax documents for Catherine Mansky-Paulson from January 2020 to present. And request number 18, produce any and all tax documents for Without a Crystal Ball, LLC from January 2020 to the present. Please produce the above referenced materials no later than 10 days from the date of this letter. If you believe any responsive material is privileged or otherwise protected from disclosure, please provide a privilege law complaint with Rule 2602 of the Minnesota Rules of Civil Procedure. Should your client continue to withhold responsive documents, particularly those she has publicly acknowledged possessing, we will immediately seek relief from the court. Next, we have Jennifer Moore responding to Amber Stavig. Ms. Stavig, this letter confirms our meet and greet confer discussion held on December 5th regarding outstanding discovery disputes. So this was sent on December 5th, directly or sometime after their discussion. What was agreed to, according to Jennifer Moore: 1. Targeted search terms for social media archives. Attached as Exhibit A are targeted search terms for plaintiffs who run against the social media archives they claim to have, quote, full access to. Please produce all responsive content with complete metadata within 14 days of the date of this letter. 2. NewsNation information. I will inquire with my client regarding communications related to her NewsNation appearances and provide you with information about those communications within 14 days. Well, that seems awfully vague. That seems like a roundabout bullshit answer, in my opinion. Whatever. 2, clarifications required. A, deleted versus deactivated social media accounts. During our call, you stated that your clients did not say they deleted their social media accounts. However, Miranda Derrick's amended affidavit, dated October 8th, 2025, paragraph 3 states, I deleted my social media presence as a result of the backlash from defendants' increased aggression this year. Well, you just proved that Amber was correct. You're saying you stated that they did not say they deleted their social media accounts. And then you provide proof that they did not say they deleted their social media accounts. They said presence. You can have an account without it being obviously present to the public, without anyone knowing about it. The presence is, here I am. The account is, I'm over here, kind of. Having the account is like, I'm here, but no one can see me. The presence is, here I am, bitch, look at me. Why is this so difficult? Why can this attorney not grasp the concept of the difference between the two words? I don't know. James Derrick's affidavit dated the same thing. I deleted my social media presence as a result of the backlash from defendants' increased aggression this year. Your November 21st, 2025 letter now claims the accounts were deactivated, not deleted, and that plaintiffs had full access to their deactivated content. Yeah. Please clarify within 7 days whether your clients deleted or deactivated their social media accounts. She's clarified this, I think, more than once at this point. It's been clarified. You've asked, you've been answered. You asking again isn't going to change the answer. If you are withdrawing or correcting those sworn affidavits, the exact nature and format of archives that exist, and whether plaintiffs can run searches against those archives and produce results per Exhibit A. 3, outstanding issues not resolved. Social media monetization records. Still outstanding after 22 months. The court's January 29, 2024 order required production of request for production, granted in part, documents sufficient to show any compensation paid to you, including monetary, in kind, or other, attributable to your social media activity. What? What does that even mean? Paid to you. And attributable. What? Anyway. Request for production 7, granted in part, documents sufficient to show any compensation paid to you, including monetary, in kind, or other, attributable to booked performances or appearances by 7M dancers. Request for production 14, granted in full. Documents sufficient to show compensation or wages paid, including monetary, in kind, or other, to its dancers and employees by 7M, reflecting any withholdings taken from the compensation. Well, what does that matter? They're a management company. Of course there's going to be withholdings. If the chances are that's how they're paid. While I appreciate that 7M Films' complete tax returns and financial statements were produced in September 2025, 19 months after the court order, but still before the end of the time allotted, the monetization records for Miranda and James Derrick remain outstanding, including Instagram earnings monetization paid directly or through 7M, TikTok earnings monetization paid directly or through 7M, brand partnership agreements and payments, documentation showing how social media income flows directly to Derrick's or through 7M, any withholdings, management fees, or splits, and that's it. These records are essential to evaluating plaintiffs' claimed $4.7 million in damages based on lost social media income and reputation. What is that? What? Reputation? Oh, whatever. Please provide within 14 days. 1. Complete production of social media monetization records responsive to requests 6, 7, and 14. Or 2. Agreement to reopen discovery so defendants can subpoena these records directly from Instagram, TikTok, and brand partners. B. Undisclosed social media accounts. I have identified 2 social media accounts that were never disclosed in your discovery responses, despite being directly responsive to our August 2022 discovery requests. 1. Wilking Sisters 2 Instagram account. contains videos of Miranda Derrick, including content discussing this lawsuit. And 2, without a crystal ball or clue, Instagram account maintained by Robert Shinn and or 7M Films publishing statements about this lawsuit. I identified these accounts over a year ago in my correspondence and declarations. You have not addressed them. Therefore, they must be yours. That's how that reads. Please confirm within 14 days, 1, who owns, controls, or has access to those accounts. 2, whether these accounts were deleted and when. 3, what archives exist for these accounts. And 4, produce all content from these accounts, particularly content referencing this litigation, defendants, or the Wilking family. C, why are they being sued? Is the Wilking family being sued? Why does evidence need to be produced regarding them? C, confidentiality designations. Under paragraph 7 of the protective order, you have the burden of proving that AEO designated materials fall within the scope of protection. Paragraph 2 limits highly confidential attorneys' eyes only to confirm the producing party deems especially sensitive, specifically private financial information, sensitive and private business information, medical records, and personal contact information. Financial documents such as tax returns may constitute private financial information, but paragraph 2 does not authorize excluding parties from accessing their opponent's financial discovery in a defamation case where damages are at issue. But Katie Joy's not asking for these documents to disprove damages. She's asking for these documents to substantiate her reporting. That seems to be like a misuse of legal tools or of litigation. Anyway. The AEO designation, quote, cannot be distributed to clients, the parties, or other individuals, including my client, who needs access to this evidence to defend herself. Under paragraph 7, you must prove good cause for AEO designation. You have not met this burden. Deposition transcripts. You have designated entire deposition transcripts as, quote, confidential without identifying specific testimony requiring protection. The burden under Rule 2603 and the protective order is on the designating party to show good cause. Please de-designate the transcripts in their entirety except for genuinely private personal information, or provide line-by-line justification with good cause within 14 days. Why? What is Katie Joy's ability to produce these transcripts to the public or to further disperse them? How does that help her case? How does that help her formulated defense? Again, this just seems like misuse of the system, in my opinion. Attorney's eyes only designations. Your November 21st letter claims Katie has a, quote, demonstrated history of publicly disseminating plaintiff's private information. This is factually incorrect. Katie has never disclosed private discovery materials publicly. Who said she did? That's not what was said. You just quoted what she said. Jennifer Moore, come on. You just quoted Amber Stavig's letter as saying demonstrated history of publicly disseminating plaintiff's private information. You just quoted that. And now you, right in your next sentence, are saying that, but Katie never disclosed private discovery materials publicly. Well, no, because she didn't have access to private discovery materials before that because the lawsuit hadn't happened. It's her sharing all of this private information that helped lead to this lawsuit where we're at today. So when was the chance to disclose the private discovery materials? See, that's just like, I'm starting to think that is she like a special attorney? The January 25th, 2025 Instagram post you reference involved a marriage certificate that was a public record obtained independently from the county recorder, not from discovery. See, here's the thing though. When Amber Stavig stated a history of publicly disseminating plaintiff's private information, I don't think that it refers to just one instance. I think that refers to multiple instances from the very beginning in 2022 to today. Why is Moore jumping on this as being the only instance of this, and this therefore must be what you're talking about, and this is why it doesn't apply? Yo, fam, there's like 15 other events that she could use as an argument after that. And all of which, and the more you dispute this, the more those are going to be made apparent and make the court aware of these instances. And the more patterns going to be established, in my opinion. That's funny. Her comments regarding the Derrick's demeanor during their depositions does not constitute information that is subject to a protective order. No, I think that's correct. It does not constitute information subject to a protective order. However, it ain't helping your case, boo. AEO designations prevent Katie from reviewing evidence in her own defamation case. This is necessary insofar as she has specialized knowledge about social media finances that I simply do not possess in my feeble mind, because she is a content creator herself. Oh, so I then have this specialized knowledge too. Is that what that means? Yay! Could I charge for my services in court cases, I wonder? Because my specialized knowledge, right? Maybe I could teach Jennifer more. Anyway, please remove all AEO designations within 14 days. Documents may remain confidential where appropriate, but Katie must have access under the protective order's existing prohibitions on public disclosure. Well, okay, so if the whole point is for Katie to be able to formulate her defense and therefore she needs access to these documents, then what does it matter if they just all go to confidential? Why are you also pushing for a lot of them to become public, available for public disclosure? Because that, to me, seems like that's the real reason for you wanting the de-designation or whatever. Yeah. The confidential designation adequately protects your clients from disclosure. Then it should also adequately provide access for your client to the documents, right? Why do you need more? 4. Defendant's tax returns. You stated you intend to file a motion for contempt regarding defendant's tax returns under request 17 and 18. As I stated on our call, you are welcome to file that motion. However, I will oppose any request for attorney's fees given that 1. Plaintiffs' production of court-ordered social media monetization records, request 6, 7, and 14, is 22 months overdue. 2. Plaintiffs took 19 months to produce their own tax returns under the same January 29 order. Well, then so did you, right? If you also did not provide tax returns, well, then they took less time than you did. Am I wrong? I don't think I am. How's that an argument in your favor? 3. I will seek attorney's fees when the court orders production of the still outstanding monetization records. Okay. I will not produce defendant's tax returns while plaintiffs remain in violation of the same court order by failing to produce social media monetization records. Oh, so in other words, you gave us the tax returns, but we're not going to reciprocate with tax returns until you also give us this. Like, that doesn't change the fact that you are under order to produce these documents. Like, that's not contingent on what the other side does. Am I wrong? I mean, I'm not an attorney, I'll be honest, but it just seems like I don't see how a court would get anything done if these things weren't understood and established. That's all I'm saying. If you are able to provide social media monetization records, I will revisit the issue of tax returns with my client. I will note that the non-dispositive motion deadline passed long ago, and you are no longer entitled as a matter of right to seek compliance with discovery. What's this? I'm going to see the thumbnail on that. This is not a bar to defendants since you were on notice that discovery was missing and you provided it after both the non-dispositive. Oh my God, you're an idiot. I will note that the non-dispositive motion deadline passed long ago, and you are no longer entitled, as a matter of right, to seek compliance with discovery. However, that's not a bar to defendants, since you were on notice that discovery was missing. So that rule applies to you, but not to me. Rules for thee, but not for me. Okay. 5. Reopening discovery. 5. Reopening discovery. It is my belief that the July 25, 2025 federal raid on Mr. Shinn's properties, the U.S. Postal Inspection Service forfeiture proceedings, and the extremely late production of financial records warrant reopening discovery for the purpose of obtaining non-privileged relevant information about the criminal investigation in your client's possession, as well as to permit me to depose Hannah Shinn and Shirley Kim. I may also seek to resume Mr. Shinn's deposition to secure testimony about the criminal investigation and financial records he provided in September. Well, isn't that what a trial would be if you had follow-up questions to that? Isn't that what you would do in a trial? You are correct that the court likely does not want to address this issue at this late date. Given Mr. Shinn's efforts to avoid testimonial jeopardy in California, the prejudice from limited reopening appears minimal. I understand that you believe Ms. Kim and Ms. Shinn are not your clients, but we understand you believe this because there was no contract signed. They didn't retain you or anything, but you're wrong. They're your clients. However, I believe that both of them are affiliated and employed by 7M insofar as their names appear throughout the financial records produced in September. That may be the case, but you still have to subpoena them, boo. I will ask the court for clarification, and if the court decides you are not obligated to make them available, I will subpoena them as third parties. Why don't you just do that to begin with? Jeez, that's just ridiculous. All right. This is the targeted search terms that Jennifer Moorside wants to have applied to the archived data from the social media accounts. So the search terms regarding defendants are as follows. Katie or Paulson, or Katie Joy, or Katie Paulson, or Catherine Paulson, or Catherine Mansky. Without a crystal ball, or without a crystal ball, or without a crystal ball, or without a crystal ball. If you're listening and not looking, there's a difference in how it's produced in, textually speaking. KJ is standalone or in context with other terms. The search terms relating to plaintiffs are as follows. 7M or 7M Films or 7M Films. Shinn or Robert Shinn or Pastor Shinn. Shekinah or Shekinah Church. Miranda or Miranda Derrick or Miranda Wilking. James or James Derrick. Miranda or Melanie Wilking or Melanie Wilking. Or Kelly Wilking or Dean Wilking. Search terms related to individuals identified in discovery. Hannah Shinn, Shirley Kim, Daniel Joseph, Priscilla or Priscilla Lee. Search terms, subject matter, allegations and claims, litigation related. Lawsuit or defamation or litigation or legal action. Attorney or lawyer or counsel or legal. Court or judge or trial. Search terms related to core allegations. Cult, trafficking or sex trafficking or labor trafficking or human trafficking. Abuse or coercion or control or manipulation. Investigation or FBI or federal or raid or law enforcement. Criminal or charges or prosecution. Here's my question though. So Katie Joy's side is wanting these search queries applied to the archived data from Miranda and James's social media accounts. Well, I'm just going to leave it at those because the other two are, it's ridiculous. But for those social media accounts, it is my recollection. Now, for granted, I didn't comb through all of their postings or whatever. But from my recollection, they never posted about Katie Joy. They never posted about the claims, or at least not much of the claims being made against them by Katie Joy. It just seems like a lot of this is not going to be applicable, in my opinion. Okay. Search terms related to business or financial. Contract or brand or partnership or sponsorship or deal. Earnings or income or revenue or monetization or payment. Instagram or TikTok or social media. Followers or engagement or content. 3. Search terms related to events and documents and specific events such are as follows. July 25th or federal raid or raid on. Netflix or Dancing for the Devil. Documentary or Hulu. 4. Search terms related to communications about defendants in direct references, meaning posts tagged with or mentioning at without a crystal ball, or at WOACB, or at Katie Joy. Posts containing links to defendants' YouTube channel, Instagram, or other social media. Screenshots or reposts of defendants' content. Search terms related to family sources, the Wilking family as Melanie or Kelly or Dean in context with Wilking family sister or parents. Wilking family or Wilkings. The search queries related to search. And then the 6 search parameters as followed. Date range from account inception through August 15th, 2025. Deletion date. Content types to include posts, grid posts, carousels, stories, including expired stories in archive, reels, videos, IGTV content, live videos if archived, comments made by account holder, captions and alt text, metadata required for all results, original post date timestamp, edit history if any modifications made, engagement metrics, likes, shares, saves, views, reach, impressions, location data if any, tagged accounts, and hashtags used, direct messages, any DMs containing the search terms above, Boolean operators. That's how you pronounce it, right? Use or within categories and between categories where appropriate. Case insensitive search. 7. Production requirements. Format. Native searchable format with all metadata intact. 2. Organized by accounts. Meaning Miranda Derrick Instagram, Miranda Derrick TikTok, James Derrick Instagram, James Derrick TikTok. Wilking Sisters 2 Instagram if applicable. Without a crystal ball or clue Instagram if applicable. Documentation, search methodology, documentation explaining how searches were conducted. 2. Declaration under penalty of perjury, confirming all searches were run against complete archives. All responsive results are included. Archives include all content from inception through deletion date, and no content has been excluded, modified, or withheld. Production deadline, 14 days from the date of the cover letter. Next piece of evidence. This is, this is funny. This is a letter from Amber Stavig to Jennifer Moore. Why is this not getting bigger for me? There we go. All right, I enlarged this here, so maybe, hopefully it's a little bit easier for everyone to read. Anyways, I'm going to take a quick break. Okay, so I enlarged this so that hopefully it's easier for everyone to read. All right, so this is a letter from Amber Stavig to Jennifer Moore, and this is dated also on December 5th. So this is in direct response to the letter we just read. Here, Amber Stavig says, "Good afternoon." Not Miss Stavig, dear Miss Stavig, just good afternoon. I am in receipt of your letter and have several objections to your characterization of our conversation this morning. I did not agree to send you targeted search terms for my client's social media accounts. I asked you to provide the discovery responses which authorizes your request. This Exhibit A appears to be an attempt to request additional documents which were not asked for during discovery. Please provide the discovery request relevant to your request for these search terms, and I'm happy to provide relevant, probable information regarding the same. As to the NewsNation issue, your client is compelled by the court's January 29 order to respond to our interrogatory 12, which state the name, address, and contact number of each and every person to whom defendants shared information with regarding 7M Films Incorporated, Robert Shinn, Miranda Derrick, and James Derrick. This includes any and all phone calls, texts, Facebook Messenger texts and calls, iMessages, WhatsApp messages, Group Me messages, Discord messages and posts, Microsoft Teams messages, emails, letters, face-to-face discussions, video calls, Zooms, Teams, FaceTime, Skype, voicemails, as well as social media posts, including but not limited to Instagram posts, videos, and lives, Snapchat, Be Real, TikTok, YouTube, Facebook, Reddit, and Twitter. State the date and content of the communication starting from January 2020 to the present. For each communication, please state who initiated contact and the content of that discussion. You have failed to provide this information in its entirety. NewsNation is just one institution Ms. Paulson has shared information with. She was the archival consultant on a Netflix documentary, and no information about who she spoke with was given for that either. We will be filing a motion for contempt for your complete failure to comply with the court's order. Ouch. Jesus. As for your request regarding deactivation, I have already clarified that their accounts were deactivated, not deleted, and that they still have access to them. I also made this correction on the record, so no further clarification is necessary for the motions that are currently in front of the court. Moore even referenced that, didn't she? Okay, so this is interesting. This is very interesting. Going up here to the top of this filing here with the evidence and going down to the first Exhibit A, which is a letter from Jennifer Moore to Amber Stavig. And in it here, going down underneath social media archives and spoliation concerns, it says here, in my July 26, 2024 correspondence and September 26, 2025 declaration, I identified serious discovery deficiencies related to social media accounts specifically. So between these two dates, I'm to believe that the December 26th date applies to the deactivation deletion discussion, because it stated elsewhere that Jennifer Moore first raised concern about the other two extra accounts on July 26, 2024. So your client submitted in sworn affidavits that they deleted their entire social media presence on or around August 15th. So that would mean that this admittance in sworn affidavits was on or before September 26, 2025, correct? Now, I remember her saying something about an amended complaint, so we search for amended, and it brings us down to page 15, or 15 of the motion. And it says here, again, under deleted versus deactivated social media accounts, Miranda Derrick's amended affidavit dated October 8th, 2025, paragraph 3 states, so it would appear that, or is that 24, I think? Okay, so this letter here, it would appear that here, when Amber Stavig says, as to your request regarding deactivation, I've already clarified that their accounts were deactivated, not deleted, and that they still have access to them. I also made this correction on the record, so no further clarification is necessary for the motions that are currently in front of the court. So according to claims from both attorneys, it would appear that Jennifer Moore asked for clarification in the form of amending the deposition or the affidavits, to which Amber Stavig went and did just that way back in October, but yet Jennifer Moore is still speaking as though this had never been done. That's how it looks to me anyways. But again, not an attorney, what the fuck do I know? As discussed during our conversation, you did not request social media monetization records in discovery. Your requests for production are vague and only state documents sufficient to show compensation. We complied with documents sufficient to show compensation. Your vague request does not equate to a request for social media monetization requests. During our conversation, you also stated that during their depositions, my clients, James and Miranda, were not aware of these monetization reports. I have not checked the transcript to confirm this, but your characterization of this request is wholly inaccurate. Though these specific monetization requests are not required due to the vague nature of your requests, we will comply and send them to you all the same. So in other words, Amber is saying, listen, boo, you didn't request that. That's not how your wording was extremely vague, and we did the best we could to decipher what it is you meant, and we sent you shit. You were not specific enough. But still, regardless of all that, we will comply and send them to you all the same. So, in other words, you didn't ask for them properly, but that's okay. We're still going to send them to you. Okay. That sounds like something that's been resolved, but okay. With respect to brand partnership agreements and payouts, we have complied with this request. Please indicate any information you believe is still outstanding with specificity. Your request for documentation showing how social media income flows is not directly related to the discovery request outlined in your letter. Please provide a relevant discovery request and clarify your question as it is unanswerable in its current form. As to your request for withholdings, management fees, or splits, this information has been provided. Further, none of the discovery requests outlined pertain to this information. In other words, you didn't even ask for that to begin with, but we still provided it. Please provide a relevant discovery request and clarify your question as it is unanswerable in its current form. Please provide the discovery request relevant to your request of the Instagram accounts identified in your letter. Paragraph 7 of the court's protective order states that the party seeking a designation change must do so within 30 days of the designation. That means within a month of us designating this document to this classification, you had to make this request. We're way past that 30 days, boo. Paragraph 7 further does not require that I designate that the AEO accounts fall within the scope of protection. Therefore, your request for redesignation is untimely and cannot be granted by the court. As to your threats regarding our motion to compel discovery, 1. As stated above, your failure to engage in tactful discovery does not create a discovery failure. What? You know, did they really just say, okay, your behavior to not do this tactfully does not equal our discovery failure? What the fuck? You failed to request specific documents in your initial filings and are attempting to request new discovery to cover up your own failure to request documents within the discovery timeline. Further, we are sending the information requested in a timely manner relative to the date of your request. Oh. So you didn't request the shit in the time allotted. You did it late. So we'll get to it, in the same time frame as the previous. 2. All tax returns were produced to you prior to today's meet and confer. All allegations of untimeliness are moot and do not allow you to violate the court order. Yep. That's what I was saying. You're still under the same order. Just because you feel like they didn't fulfill their obligations does not excuse you from yours. 3. Please see response to paragraph 1. Thank you for your statements that you intend to continue to violate the court's order. I will be sure to include that in our contempt filings. As stated in our conference, you were aware of Ms. Kim and Ms. Shinn's involvement with my clients during discovery. You sent requests for their depositions to me, and I informed you that I was unable to force people who are not my clients to attend a deposition. So far as I'm aware, you never set up depositions of either of them. Further, the federal raid done on my clients' properties was entirely to your own client's behavior. It was in no way proof that she was telling the truth, but in fact, further damages to my client due to her complete disregard for the truth. No fucking... Amber Stavig just confirmed that the federal raid done on Shinn is entirely to Katie Joy. Holy shit. I mean, we all knew that, really. I mean, realistically, we all knew that, even if we didn't know that. But now I feel like we fucking know that. That's crazy. But she's just a journalist, y'all. She deserves protections from doing that, right? Mm-hmm. But don't you dare call anyone on her, right? Or still, don't call on her. That's two wrongs don't make a right. But I'm just saying, the hypocrisy. Miss Kim and Miss Shinn are not my clients. I cannot compel individuals who are not my clients to do anything. Okay, Exhibit 8. That was interesting. I'm guessing these things here are not, are under some sort of disclosure thing or whatever. Maybe. Okay, Plaintiffs Rule 2601 disclosures. Two defendants, initial disclosures. Oh, so this is just, okay. So we already read what it is they asked for in the discovery request. This is just evidence or proof, an exhibit of evidence to provide reference to these requests actually being requested in discovery. So, all right, I'm not going to read all that. Okay, that's the end of that one. And the following of these is mostly shit that's already been read or already been submitted. Like, we come across these letters, some of these letters more than once, because I think both attorneys submitted them as evidence. So there's more than one filing of the same thing, basically, by both sides. So this here is plaintiff's notice of motion and motion for contempt and sanctions. So this here is plaintiff's notice of motion and motion for contempt and sanctions. So in other words, everything that Amber Stavig had just threatened to do is in terms of filing for contempt and for sanctions, she, in fact, has done through this motion. So everything that she said that she was going to include, she's included. Everything we just read, all the deficiencies or whatnot, that's what this is. This here is from Amber to Jennifer Moore. Pursuant to the court's prior order on discovery, and what's this dated? November 21st, okay. Pursuant to the court's prior order on discovery and in accordance to Minnesota Rules of Civil Procedure, we hereby formally demand the immediate production of all discovery materials that your client, Katie Joy, has represented to be in her possession, custody, or control. So this it pertains to the dozens of clips she mentioned in the June 24, 2025 video she put on YouTube, as well as any communications or other information related to her appearance on NewsNation and any other interviews or media requests she had fulfilled or discussed or entertained, whatever. And then they repeat the request numbers of the interrogatories that represent this initial request. That's what that is. This is from Ms. Moore. What's the date on this? This is on December 12th. Oh, it says, oh no, this one was filed. This is actually sent by e-service December 5th. Oh, well, we already read this. I'm not reading it again. I'm not. Okay. Did I put that up twice, maybe? I don't know. Plaintiff's first set of requests for production of documents. Again, just providing, again, the interrogatory information, requests, definitions, whatever, for the things that Amber Stavig has been asking for that have yet to be fulfilled. This here is plaintiff's first set of interrogatories. I might have put this up here twice. I don't know. Okay. This is objections to letter to Jennifer Moore. This is dated December 10th. Good afternoon. I am in receipt of your letter and have several objections to you. Oh, I already read this. Oh, that's right. Jennifer Moore provided this letter in her evidence exhibits, and this must be Amber Stavig presenting it, providing it in support of hers. This here is a screenshot of the June 24th, 2025 video that Katie Joy uploaded. It was titled, do we even have the title here? Oh yeah. The 10 million lawsuit against me just collapsed. This is huge. And it says, after more than 3 years, I claimed a big victory in court with more than half of the lawsuit against me being thrown out by a judge. I also won when the judge refused to rule a summary judgment against me. This means I won't have to pay $10 million to Robert Shinn, Miranda, and James Derrick, while part of their claims stuck. Sure. We have tons of evidence to prove our innocence. That's precisely what they're after. And this is the transcript for that video. I'm not going to read it all. This is 7 pages of Katie Joy's rambling. I'm not going to do that to those listening, and I'm not going to do that to myself. I'm not a masochist. But yeah, the video is still up, last I knew, and you can always obtain the transcript through YouTube, or you can obtain it from the Minnesota court case website, as such as I have, or you can just play this video and pause it and stop and read should you want to see anything. I'm going back through it the other way now for you. And there's that. And this is the rest of it. Oh no, this is the transcript for when she was on NewsNation. Yeah, this is still up on NewsNation, or you can download it from the Minnesota court website. And this is the second time she was on NewsNation. Again, it's still up, or the Minnesota court website. And then here, let me put that over there and close that. All right. This is Plaintiff's Memorandum of Law in support of motion for contempt. So this is just documenting everything that's already been documented through all the letters that we just read. I'm not reading this. We've already gone over this information. I will scroll through it slowly, though, like I am, should anyone want to read it. Or again, you can download it from the Minnesota State Courts case search website. I'll provide a link to that website in the description for anyone. It's real easy. All right. So there's that. And then lastly, we have Affidavit of Amber Stavig. This is just detailing what she submitted as evidence and what she's basing what her argument is supporting her request of the court. So there. That's it. That's all of it. Yeah. I left plenty of commentary throughout this video, and I'm just going to let that stand as it is. But this, I have to say, this was quite interesting for me. Like, normally my reading of these court cases, it's not something I particularly enjoy because it's just boring as hell. I mean, it's law. You're reading about law. You're reading about people who think way too much and reading about what they think about law. And the only thing worse maybe might be tax law. I think that might be worse than civil law. And I think the only thing civil law might be worse than is like criminal law. Criminal law might be the most interesting. This is like a far second and then an even farther third for tax law. But yeah, but this, I don't know. I can't get into the subject. I just can't. It's like philosophy to me. Nothing against philosophy or those who study philosophy. It's an important subject and should definitely be discussed because we need new ideas. We need, examples of how and when and what it looks like to think outside the box and whatnot. Yes, I fully support philosophy. I just don't want to do it. Like, I'll have discussions, but learning about philosophy and how it's structured, or the foundation of it, the premises and the conclusions and the I don't even know. I can't even think of the terminology for all this shit. But it reminds me of, okay, so in elementary school, the bathroom there, when you walked into the bathroom, to your right, you had like 4 or 5 sinks lined up, and then a mirror above each sink. And then directly behind each one of those sinks and mirrors, you had the same thing on the other side. So directly in back of you, standing in front of a mirror, you had a mirror. And then, so if you looked into this, you had this like never-ending line of mirrors because there's reflection after reflection after reflection after reflection. You know what I mean? Well, philosophy to me is kind of like that. Only you're standing in like a sphere, maybe not even a perfectly round sphere, but a rounded like object. And all over the surface inside of this round object, there's broken pieces of mirrors, and it covers the entire surface pretty much. So anywhere you stand, anywhere you look from that position, you have never-ending reflections that go on forever. And I feel like that's what it's like when you consider all the different premises and variables and whatever. There's an exception for everything. There's an explanation for everything. Nothing is concrete. And everything's subject to change depending on the interpretation. That's really the best like visual image I can give for how, I don't know, convoluted philosophy is. And law is right behind it, in my opinion. So, but this one was interesting. I just went on a tangent explaining why I think this one was interesting, I guess. But it was. Maybe because I'm aware of a lot of the parties and a lot of the events that are being discussed in it. And maybe it's because, like, sure, we all saw Katie Joy do this fucked up thing for so long. Now she's being held to task for it. That is definitely something that I'd be here for. I mean, I don't wish for anything bad to happen to Katie Joy, but I mean, for once, I would like to see those harmed by her acknowledged by a court, by the public, by whatever. It would be nice to see the actual people who are left in the aftermath, the wake of her drive-through, receive some sort of acknowledgement and compensation. That's all. That's my only interest. But it's still enough to make it interesting. So I hope you enjoyed it. Have a good day, night, whatever. And I'll see you later. Bye, guys. Now it's time for member shoutouts. I'd like to thank Fayette, Mr. Blackwolf, Jill B, C. Catsam, Channel Has Been Deleted, Sally Godfrey, Channel Has Been Deleted, Randall Smith, Estella Havisham, Rena Rue 2U, Sean Coffey, Flying Mom Laura, Berillian, Jen Gerard, and Poodlerific. Thank you very much for joining, and thank you everyone for watching.